SchnitzelNinja.
In the Arizona Court of Appeals, Division 2, Laura Owens, Petitioner Appellant, versus Clayton Echard, Respondent Appellee, number 2CA-CV2024-0315, filed March 28, 2025. This decision does not create legal precedent and may not be cited except as authorized by applicable rules, not for publication. Appeal from the Superior Court in Maricopa County, number FC 2023-052114. The Honorable Julie A. Mata, Judge. Affirmed. Counsel, Gingras Law Office by David S. Gingras. Woodnick Law, PLLC by Marcus Reisinger. Owens v. Echard, Decision of the Court. Memorandum Decision. Judge Vasquez authored the decision of the court in which presiding Judge Eckerstrom and Judge Sklar concurred. Judge Vasquez. In this paternity action, Laura Owens appeals the trial court's award of attorney fees and costs in favor of Clayton Echard. She argues that Echard's, quote, failure to comply with the safe harbor requirements of Rule 26 preclude sua sponte sanctions, end quote, under any authority, and that the amount of fees awarded was unreasonable. She also argues the court committed structural error by conducting its own post-trial investigation into the facts of the case. For the following reasons, we affirm. Factual and procedural background. We view the facts in the light most favorable to sustaining the trial court's findings and orders. Hefner versus Hefner. In May 2023, Owens and Echard had an intimate encounter. Shortly thereafter, Owens learned she was pregnant. In August 2023, she filed a paternity petition alleging Echard was the father. Echard denied paternity. In December 2023, the case was placed on the administrative dismissal calendar for lack of prosecution. Echard moved to extend the dismissal date, arguing that he was, quote, entitled to an adjudication finding of non-paternity, end quote. He also requested an evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions. In response, Owens informed the trial court she, quote, was no longer pregnant, end quote, and thus, quote, there was nothing left to adjudicate, and this case should be dismissed, end quote. She simultaneously moved to dismiss the case with prejudice. Echard opposed. Echard then separately moved for Rule 26 sanctions, arguing Owens' petition was filed for an improper purpose. Her motion to dismiss was, quote, unsupported by existing law, end quote, and her, quote, factual contentions were not supported by evidence and did not become supported by evidence after investigation and discovery, end quote. Owens responded that Echard had not complied with Rule 26 requirements because he did not provide her with, quote, written notice of specific conduct alleged to have violated Rule 26, end quote, and that she was, therefore, not, quote, afforded time to cure any alleged deficiencies, end quote. Echard eventually moved to withdraw his Rule 26 motion, arguing that, quote, there was no reason to participate in the pointless litigation over this issue, notwithstanding his disagreement with Owens' legal positions on Rule 26, end quote, because Rule 26 was, quote, not the substantive pleading basis for his claims, end quote, for attorney fees and sanctions. The court extended the dismissal deadline, denied Owens' motion to dismiss, and set an evidentiary hearing on, quote, the issue of sanctions and attorney fees, end quote. After the evidentiary hearing in June 2024, the trial court granted Echard's request for attorney fees and costs. In July, Owens filed a notice of change of judge for cause under Rule 6.1 Arizona Family Law, arguing the judge was biased and had engaged in conduct that violated her right to due process. The presiding judge denied her motion, concluding Owens had failed to prove by a preponderance of the evidence that the judge was biased or prejudiced. Also in July, Owens moved for relief from the judgment or, alternatively, to alter or amend the judgment, which the court ultimately denied. In August, the court awarded Echard attorney fees and costs in the amount of $149,219.76. This appeal followed. We have jurisdiction under A.R.S. 12-120.21 and 12-2101A1. Footnote 1. The trial court's August 2024 judgment was not certified as final under the applicable rules, and the June 2024 ruling was improperly certified as appealable under Rule 78B. We therefore suspended the appeal and revested jurisdiction with the trial court to allow it to enter a final appealable order. After that, court amended the August 2024 judgment to include the requisite finality language under Rule 78C. We vacated the stay and revested jurisdiction in the court. Discussion. 1. Attorney fees. Owens argues that because Echard did not comply with Rule 26 safe harbor requirements, she was, quote, shielded from any punishment arising from her alleged violation of Rule 26, end quote. Footnote 2. Rule 26B provides that by signing a court filing, a party is, among other things, certifying that it is not being filed for an improper purpose. The claims are supported by existing law and are non-frivolous, and the factual contentions have evidentiary support. If a party violates the rule, the trial court may impose sanctions, including reasonable attorney fees. Arizona Family Law 26C. However, before seeking sanctions under the rule, the moving party must attempt to resolve the matter by consultation. Arizona Family Law Rule 26C2. As a preliminary matter, we note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded, quote, attorney fees and costs under A.R.S. 25-324 and 25-415. We thus declined to consider whether an award under Rule 26 would have been proper. Footnote 3. In its ruling, the trial court ruminated about whether it could sua sponte award sanctions under Rule 26 after a party moves and then withdraws a motion for Rule 26 sanctions. Presumably, it did so because this question was heavily litigated by the parties below. Ultimately, however, the court did not award Rule 26 sanctions. See Freeport McMoran Corps versus Langley Eden Farms. Appellate courts do not decide unnecessary issues or issue advisory opinions. We review the trial court's decision to award attorney fees and sanctions under A.R.S. 25-324 and 25-415 for an abuse of discretion. Merrick v. Maloney, 325 Arizona 491. Hayes v. Gamma, discovery sanctions. But we review a court's interpretation and application of statutes de novo. Clark v. Clark, Ripe v. Ripe. Owens argues that because the hearing was set in response to Echard's Rule 26 motion, and because he did not file any other motion for fees or sanctions, quote, of course the court sanctioned her under Rule 26, end quote. Relying on Rule 35A1, Arizona Family Law, Owens contends a fee or sanctions request must be made by separate motion. While this is true for Rule 26 sanctions, 26C3A, the same is not true for attorney fees and requests under 25-324. See Lundy v. Lundy, or sanctions for litigation misconduct under 25-415, Hayes. Court can impose discovery sanctions under its, quote, inherent contempt power, end quote. Nevertheless, Echard properly requested attorney fees and costs under those authorities throughout the litigation. For example, he requested attorney fees and costs under A.R.S. 25-324, quote, based on Owens' unreasonableness, end quote, in his motion to extend the dismissal date on the inactive calendar and to schedule an evidentiary hearing, which was filed before Owens moved to dismiss the case. Echard made the same request under A.R.S. 25-324 in his reply, as well as in an amended response to the paternity petition. Moreover, in Echard's motion to withdraw his Rule 26 motion, he argued that he was entitled to attorney fees and costs under A.R.S. 25-324, 25-415, and 25-809G, and that his, quote, claims for fees and sanctions exist independently, end quote, of Rule 26. Footnote 4. Echard repeated this argument in his response to Owens' combined motion for judgment on the pleadings and his renewed motion to dismiss. The court found Owens' motion to be moot and, quote, declined to take further action, end quote. However, there was a delay in the parties' receipt of the court's ruling, and the court found this motion was, quote, filed with the belief the court had not accepted Echard's motion to withdraw, end quote. These requests were also repeated with supporting arguments in his pretrial statements. Owens argues the trial court lacked the authority to impose attorney fees and sanctions independently from Rule 26 because Echard filed and subsequently withdrew the Rule 26 motion. She maintains that Rule 26, quote, must control and must provide the exclusive remedy, end quote, for conduct that would fall under Rule 26 violation. In support of this argument, she relies on the proposition that when, quote, two rules deal with the same subject, the more specific rule controls, end quote, in remarriage of Thorne. But the statutes under which the court granted attorney fees do not govern the same subject matter as Rule 26. Section 25-324 governs attorney fees, not sanctions. And the sanctions for costs and attorney fees that the court ordered under Rule 25-415 were based on Owens, quote, knowingly presenting a false claim and knowingly violating a court order compelling disclosure or discovery, end quote, which is distinct from conduct that would constitute a Rule 26 violation. Compare A.R.S. 25-415A3 with Rule 26C. We decline to, quote, hastily find a clash between a statute and court rule, end quote, Duff v. Lee, especially when the statute and rule govern different subjects. Owens next argues that the attorney fees and costs awarded under 25-324 and 25-415 were improper because they were neither, quote, necessary nor reasonable, end quote. She asserts Echard's fees, quote, were literally $0, end quote, prior to November 2023, and if his counsel had, quote, simply picked up the phone in mid-December and asked her about her intentions, she would have informed him that she was no longer pregnant, and there was nothing further to litigate, end quote. She similarly argues that Echard's decision to file the Rule 26 motion was the precipitating factor in incurring fees. She contends that if Echard had, quote, done nothing, end quote, the case would have been administratively dismissed, quote, without a single dollar of fees incurred by either side, end quote. Therefore, she maintains that even if her petition were unreasonable, it was not the filing itself that caused fees to be incurred, but rather Echard's choice to pursue sanctions. But that administrative dismissal would have been without prejudice, so it would not have precluded Owens from initiating a future paternity action. Nor would that dismissal have been equivalent to the order Echard sought, and ultimately obtained, that he was not the father in connection with the alleged pregnancy. At any rate, none of these scenarios posited by Owens have any bearing on the propriety of the fees awarded in this case, as that determination must be based not on conjecture, but on what actually occurred. At the time of Echard's request for an evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions, Owens had not informed him that she was going to move to dismiss the case. And in her response to Echard's request, filed simultaneously with her motion to dismiss, she acknowledged that, quote, the only remaining issue was Echard's request for attorney fees, end quote. Echard objected to Owens' motion to dismiss, arguing her avowal that she was, quote, no longer pregnant, end quote, was insufficient to grant a dismissal. He also requested an, quote, adjudication that she was never pregnant, or at least that she was never pregnant by him, end quote, and an evidentiary hearing on his attorney fees request. The trial court ultimately granted Echard's motion to extend the dismissal deadline, stating, quote, the issue of sanctions and attorney's fees remain, end quote. Owens does not challenge this ruling on appeal. And the fact that the parties incurred attorney fees because they heavily litigated these issues was within the court's discretion to consider, and not something this court will reweigh. Here, the trial court found Owens had, quote, acted unreasonably in the litigation, end quote, by filing the case, quote, without base or merit, end quote. See A.R.S. 25-324. Court may award attorney fees after considering, in part, quote, the reasonableness of the positions each party has taken throughout the proceedings, end quote. See also Maggie versus Maggie. An applicant need not show both a financial disparity and an unreasonable opponent in order to qualify for consideration for an award. The court has also found it, quote, disingenuous at best, but certainly misleading to the court, end quote, that Owens had testified the purpose of her motion seeking mediation was to inform Echard the pregnancy was not viable. It further found she had failed to comply with disclosure requirements, which, quote, caused Echard to incur substantial legal fees attempting to locate records that may or may not have existed, end quote. The court also concluded that A.R.S. 25-324B applied because Owens had, quote, provided false testimony as to the viability of the pregnancy, end quote, and had sent Echard a letter prior to her deposition that, quote, indicated her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated, end quote. On appeal, Owens does not meaningfully challenge these findings, but instead argues that A.R.S. 25-324 does not apply in paternity actions. Sections 25-324A permits a court to, quote, order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any proceeding under Chapter 3 or Chapter 4, Article 1 of this title, end quote. Chapter 3 governs dissolution of marriage, and relevant here, Chapter 4, Article 1 governs legal decision-making and parenting time. Owens argues that paternity actions are, quote, by definition, end quote, excluded. A family court's authority to conduct legal decision-making and parenting time proceedings is provided by A.R.S. 25-402. Under that statute, a parent is required to request such a determination in, quote, any proceeding for marital dissolution, legal separation, annulment, paternity, or modification of an earlier decree or judgment, end quote. A.R.S. 25-402b1. See Tanner v. Marwell. Here, Owens petitioned the trial court for orders concerning paternity, legal decision-making, parenting time, and child support. While the court ultimately did not issue legal decision-making and parenting time orders, Echard, quote, defended any proceeding under Chapter 4, Article 1 of this title, end quote, by virtue of Owens' petition, as was reflected in his amended response, A.R.S. 324A. Even assuming the trial court's fee award was improper under 25-324 because of this case's procedural posture, the court's findings would have supported a fee award under 25-809G. See Forst v. Rodriguez. We may affirm trial court if legally correct for any reason. Echard cited 25-809 in seeking attorney fees, so the issue was also properly before the court. The language in A.R.S. 25-809G largely mirrors that in 25-324A and permits a court to, quote, order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding, end quote. We reject Owens' suggestion that this paternity action somehow transformed into some other type of proceeding because the parties only incurred fees after it was scheduled for administrative dismissal without prejudice. The court did not err in awarding attorney fees. The trial court also properly awarded fees and costs as a sanction under 25-415. The court found that fees under this statute were appropriate because Owens had, quote, knowingly violated a court order compelling disclosure or discovery, end quote. Owens argues she fully complied with the court's disclosure order and was, quote, demonstrated by the fact Echard never brought any motion seeking sanctions under A.R.S. 25-415, end quote. She argues because no motion had been filed, she did not have the opportunity to prove she fully complied with the court's order. Although 25-415 does not require the filing of a separate motion, as previously noted, Echard requested relief under this statute. Section 25-415A3 states that, quote, the court shall sanction a litigant for costs and reasonable attorney fees incurred by an adverse party if the court finds that the litigant violated a court order compelling disclosure or discovery, end quote. Footnote 5. Section 25-415A3 provides two exceptions. If, quote, the court finds that the failure to obey the order was substantially justified or that the other circumstances make an award of expenses unjust, end quote, it is not required to impose sanctions. The trial court made no such findings here. Here, the court made such a finding. Thus, it was required to sanction Owens for the costs and reasonable attorney fees Echard had incurred. Owens does not meaningfully challenge that finding. Again, the court did not err in awarding Echard his costs and reasonable attorney fees. On appeal, Owens also claims that the amount of the fee award was unreasonable. The substance of her argument is that below she had, quote, noted the amount of fees was patently unreasonable in light of the controlling standard of Ethical Rule 1.5, end quote. But because she, quote, fails to identify with any particularity what evidence supports, end quote, her argument, quote, we conclude that the court did not abuse its discretion in fixing the amount of attorney's fees it awarded Echard, end quote. A. Minor Contracting, Inc. versus Toho Talani. 2. Denial of motion for relief from judgment. Owens argues that the trial court erred by denying her motion for relief from judgment, or alternatively, to alter or amend the judgment. We review the denial of such motions for an abuse of discretion. Pullen versus Pullen, motion to alter or amend judgment. Quijada versus Quijada, motion for relief from judgment. Because Owens does not argue how the court erred in denying her motion, but instead asserts that the, quote, only available remedy, end quote, is, quote, automatic reversal, end quote, because the, quote, misconduct is per se structural error of the most obvious kind, end quote. We do not address the court's denial of her motion. See Polanco versus Indus. Underdeveloped argument waived on appeal. 3. Judicial bias. Owens argues the trial court improperly, quote, performed an independent and undisclosed investigation into the facts of this case, end quote, and from this investigation, quote, made post-trial findings, end quote, not based, quote, on the evidence admitted at trial, end quote. In the findings of fact section of its ruling, the court stated that Echard's expert had, quote, testified that Planned Parenthood is not open on Sundays, when Owens testified she sought care July 2nd, 2023, a Sunday, end quote. The parties agree the expert did not testify that Planned Parenthood is closed on Sundays, and that the court's finding was therefore erroneous. Instead, they dispute which standard of review should apply. Owens argues this amounted to structural error requiring automatic reversal because it, quote, proves the trial judge was biased, as shown by the judge's decision to engage in unlawful conduct which violated her right to due process, end quote. Conversely, Echard argues that, quote, the controlling standard for alleged mistakes in family law proceedings is harmless error, end quote. Structural error is generally applied in criminal cases and is error that affects the framework within which the trial proceeds, rather than simply an error in the trial process itself. State versus Henderson. Quote, the Supreme Court has defined relatively few instances in which we should regard error as structural, end quote. But one of those instances is, quote, a biased trial judge, end quote. State versus Ring. We nevertheless decline to apply a structural error analysis given the record before us. Here, Owens moved for a change of judge for cause under Rule 6.1 on the basis of bias and prejudice within the meaning of A.R.S. 12-409b5. The presiding judge denied her motion. While acknowledging that the trial judge's finding about Planned Parenthood's business hours was clearly erroneous, the presiding judge concluded that Owens had, quote, failed to show by a preponderance of the evidence, end quote, that this finding, quote, reflected bias or prejudice against her, end quote. Owens contends that we need not, quote, separately decide whether the presiding judge erred when she denied Owens' notice of change of judge for cause, end quote, because the requested, quote, relief is subsumed within the structural error arguments, end quote, that we, quote, must review de novo, end quote. But as we explain below, the record does not show that the trial judge was biased. Thus, even assuming without deciding that structural error applies in family cases, it did not occur. And the presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. See Stagecoach Trails, MHC LLC versus City of Benson. Quote, we review for an abuse of discretion the denial of a motion for change of judge based on a claim of judicial bias, end quote. Owens argues the trial court's erroneous finding of fact demonstrated it was biased and therefore committed structural error. Her argument is based on conjecture. She does not provide any evidence showing actual bias. Her claim of bias is based on her assertion that the court intentionally, quote, tried to conceal its misconduct, end quote, in, quote, performing its own post-trial investigation into the facts, end quote, by, quote, falsely attributing the testimony, end quote, to Echard's expert. Owens claims this is the, quote, only plausible conclusion, end quote, given that online supporters of Echard had, quote, vociferously posted about this issue online hours after the trial ended, end quote. These unsupported and speculative allegations fail to meet her burden to prove bias by a preponderance of the evidence. State versus Ellison. Owens further contends that, quote, any independent factual investigation by a trial judge is unlawful and shows bias, end quote. But for structural error review to apply, the type of judicial bias that must be shown is that which implicates a party's due process rights, quote, such as bias based on a direct, personal, substantial pecuniary interest, end quote. State versus Granados, quoting Toomey versus Ohio. None of those grounds apply here. We therefore review for an abuse of discretion. Stagecoach Trails, MHC LLC. While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias apart from any structural error claim, see State versus Emanuel, the critical inquiry that would require reversal is whether the conduct demonstrates an, quote, extrajudicial source of bias or deep-seated favoritism, end quote. Stagecoach Trails, MHC LLC. Owens correctly notes that the court misstated trial testimony. But she is incorrect in asserting that, quote, because harmless error analysis does not apply, end quote, she does not need to make a separate showing of resulting prejudice. Quote, prejudice will not be presumed, but must be evidenced from the record, end quote. Town of Paradise Valley versus Laughlin. Quote, unless justice requires otherwise, an error by the court or party is not grounds for disturbing a judgment or order, end quote. Therefore, even if the court conducted independent research under a prejudice analysis, we would still have to determine whether Planned Parenthood's business hours were, quote, vitally important, end quote, to the court's ultimate conclusions, as Owens claims. However, Owens does not argue prejudice. Consequently, the presiding judge did not err in denying Owens' motion for change of judge for cause. The record does not show judicial bias, and Owens does not challenge any of the presiding judge's rulings under the appropriate standards for appellate review. See Polanco. 4. Attorney fees on appeal. Owens and Echard request their attorney fees and costs on appeal under 25-809G. Echard additionally requests fees and costs under 25-324. Under both statutes, the court may award attorney fees and costs, quote, after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings, end quote. 25-324A, 25-809G. While the record does not support the disparity in the parties' financial resources, Owens' position on appeal is unreasonable. See Maggie, 206 Arizona 589 N1. Her Rule 26 argument is not grounded in law or fact. Likewise, her assertion that the trial judge was biased and committed structural error does not meaningfully address the trial court's rulings below and also ignores the applicable jurisprudence. We, therefore, award Echard his reasonable attorney fees and costs on appeal upon his compliance with Rule 21. See A.R.S. 25-809G, Fees, 12-341, Costs. Disposition. For the foregoing reasons, we affirm the trial court's judgment.
SchnitzelNinja!